Imagine for a second that you're going to buy a new car. Like you walk into the dealership, you've got your life savings in your pocket, and you are ready to make a massive financial commitment.
Right. A really big deal.
Exactly. But instead of showing you a car or, even a 3D model, the salesperson just hands you a blurry pencil sketch on a napkin.
A napkin.
Yeah. And they tell you to hand over 90% of the money right now. And maybe in 3 or 4 years, they'll build the car.
Yeah.
Oh, and by the way, they reserve the right to change the size of the engine, paint it a different color, and this is the crazy part, double the price if they just feel like it.
I mean, you would run out of that dealership immediately. No rational person would ever agree to those terms for a vehicle.
Nobody would. But for decades, millions of people accepted an identical setup for the single most expensive purchase they will ever make in their entire lives.
Yeah, it's wild when you frame it like that.
It really is.
Yeah.
So welcome to today's custom-tailored deep dive. We are talking about the exhilarating but historically absolutely terrifying experience of buying under construction real estate.
Terrifying is definitely the right word for it.
Because, when you buy a smartphone, you get a smartphone. When you buy an unbuilt house, you are essentially buying a piece of paper.
Right, and that piece of paper is formally known as the builder-buyer agreement. And understanding what it actually represents is honestly the only thing standing between a buyer and complete financial ruin.
And that is exactly our mission today. We're looking at a massive stack of incredibly detailed legal and governance papers analyzing the builder-buyer agreement in India.
It's a lot of material.
It's a ton. These documents break down a seismic shift in the law, specifically the Real Estate Regulation and Development Act of 2016.
Which we'll just be calling RERA from now on.
Right, RERA. And we're also looking at the Consumer Protection Act of 2019, plus a whole wave of radical Supreme Court jurisprudence. So our goal is to demystify this massive stack of legal jargon to transform you, the listener, from a vulnerable buyer into an empowered, rights-bearing consumer.
To do that effectively, though, we really have to establish the central thesis of these sources right from the start. A builder-buyer agreement, or what RERA calls an agreement for sale, has fundamentally changed. It is no longer just a private, secret contract drafted by a builder's legal team to protect their own interests.
Right.
It has been transformed into a statutory compliance document. A printed clause on a piece of paper can no longer defeat the law, it cannot override consumer rights, and it cannot violate public policy.
Okay, let's unpack this. Because to truly appreciate the legal armor that buyers have today, we first have to understand the battlefield as it used to be.
Oh, the Dark Ages.
Yes. The sources actually refer to the era before RERA as the Dark Ages of real estate. But before we get into the horrors of that time, let's just look at the mechanics. What is this document actually supposed to do? Like when you strip away the legalese, what is the skeleton of a builder-buyer agreement?
Conceptually, it's a bridge. It's the contractual bridge spanning the gap between the moment you put down a booking amount and the day you are finally handed the keys and a registered conveyance deed.
Okay, that makes sense.
And the research breaks its function down into 5 core roles. The very first one is just identifying the parties involved.
Which, sounds incredibly straightforward. It's me, the buyer, and them, the builder.
Right. You'd think so, but the sources point out that real estate development is rarely that simple. It's often this huge, complex web of entities.
Ah, right, because of landowners and stuff.
Exactly. You have the promoter who is marketing the project, but they might not actually own the land. So the agreement has to explicitly identify landowners, any confirming parties, or development rights holders.
Because if something goes wrong...
Right. If a project goes bankrupt, you need to know exactly which corporate entity holds the legal liability to refund your money.
Wow, okay. So that's role 1. What's the second?
The second functional role is identifying the exact property.
And again, we aren't just talking about a marketing name like, Sunset Meadows, Tower B. We need granular detail here.
Down to the square inch. The agreement must legally define the specific tower, the apartment number, the floor, the attached balconies, the exclusive open terraces.
Even the parking spots, right?
Yes, the specific parking spots assigned to you and your undivided proportionate share in the common areas of the entire project. All of it has to be defined.
Okay, then we get to the third role, which is where the anxiety usually kicks in for people, recording the financial structure.
Always the stressful part.
Yeah, because this isn't just the sticker price of the house. It's the base price, the statutory taxes like GST, the massive stamp duty charges.
Don't forget the advanced maintenance deposits.
Right. Advanced maintenance, club membership fees, and like electricity connection charges. Basically, everything has to be captured.
Which naturally leads directly into the fourth role, and that is fixing performance obligations. I mean, a contract is essentially just a promise to perform.
So for the builder, performance means construction.
Exactly. What is the timeline? What is the definitive date they will offer possession? What specific amenities are they legally bound to deliver?
And for the buyer, performance just means paying on time, adhering to the payment schedule.
Right. And finally, the fifth role is setting out the remedies.
The what if it all goes wrong section.
Pretty much. When things inevitably go off the rails, like if the builder stalls construction or if the buyer, loses their job and defaults on a payment, what is the agreed upon structure for interest, refunds, cancellation, and dispute resolution?
Got it. So those 5 elements, the parties, the property, the price, the performance, and the remedies, they make up the functional anatomy of the agreement.
That's the skeleton, yeah.
But the muscle and tissue covering that skeleton in the pre-RERA days were completely deformed. I mean, the sources describe a landscape dominated by standard form contracts that were presented on a strict take-it-or-leave-it basis.
Yeah, there was zero negotiation.
None.
That phrase, take it or leave it, really goes to the heart of the problem. It is the defining characteristic of unequal bargaining power.
Right.
You have a single individual, perhaps buying their very first home, sitting across a table from a massive corporate entity with teams of lawyers. The buyer didn't have the leverage to negotiate a single comma.
You either signed where the sticky notes told you to sign or you just lost the apartment.
Precisely. And because of that terrifying power imbalance, the clauses inside these contracts became incredibly abusive over time.
I want to walk through some of these historical traps, actually, because they really paint a picture of how wild the industry was. Let's start with possession dates.
Oh, this is a classic.
Because if I sign a contract to buy a product, I expect a delivery date, October 1st, 2025. Something concrete.
You would expect a calendar date, yeah. But builders avoided them like the plague. A typical pre-RRA agreement would use incredibly vague phrasing. They would write something like, possession will be offered within 36 to 42 months from the start of construction.
Which sounds totally reasonable until you realize the buyer has literally no idea when construction officially starts.
Exactly. The start date wasn't tied to the date you signed the agreement or even the date you handed over your down payment.
Wow.
The builder retained the unilateral power to decide when construction commenced. They might argue that construction didn't officially start until they received some obscure internal environmental clearance.
Or until they finished another project entirely.
Right, or finished excavating a completely different phase of the site. It was basically a contractual loophole designed to allow them to delay the project indefinitely without triggering any accountability whatsoever.
That is infuriating. Then we have price escalation clauses, which, this just blows my mind. You agree to buy a house for $1 million, you secure your mortgage, you sign the papers, but the builder embeds a clause saying they can unilaterally increase the cost of the house if the raw materials get more expensive.
And the kicker is they didn't even have to prove it to the buyer.
Wait, really? No proof?
No proof at all. They would simply send a demand letter stating that cement or steel prices had risen or, labor costs had escalated, and suddenly your agreed-upon price skyrocketed by 15%.
So the buyer was forced to absorb the builder's entire business risk.
Exactly. But the most notorious trap, the one that really caused the most heartache, has to be the area changes, the infamous super built-up area.
Oh, yes.
What's fascinating here is how opacity was deliberately weaponized to extract money from buyers. In the olden days, builders sold apartments based on the super built-up area.
Which is basically invisible air, right?
Yeah, basically, yeah. It included your actual apartment plus a proportionate, mathematically opaque share of the lobbies, the staircases, the elevator shafts, the security guard's cabin.
Even the clubhouse sometimes.
Yes. You're paying for a piece of the clubhouse in your square footage.
So you buy an apartment thinking it's, say, 1,500 square feet. You move your furniture in, and suddenly your couch doesn't fit in the living room.
Right.
You measure it, and your actual living space is only 900 square feet. The other 600 square feet is your theoretical share of the elevator shaft.
It was a prime tool for manipulation. A builder could unilaterally declare that the building's design had changed,
right?
And therefore your super built-up area had increased by 10%.
And then they'd bill you for it.
Exactly. They would demand a massive extra payment for this additional space. But when you walked into your apartment, your bedroom hadn't gotten any bigger. You were paying for an expansion of the lobby downstairs.
Which is why the modern legal shift to carpet area is such a monumental victory.
It alters the entire economic reality of the transaction. I mean, carpet area is exactly what it sounds like. The actual usable internal area of your apartment where you can physically lay down a carpet.
So the walls, the shafts, the lobbies are all excluded.
Yes. By forcing builders to price and sell apartments based solely on carpet area, the law stripped away that opacity. You are finally paying only for the space you can actually inhabit.
That makes such a huge difference.
Hmm.
Okay, we also have to talk about the penalty imbalance because this really highlights the sheer arrogance of those old standard form contracts.
The imbalance was staggering.
Let's do the math on this. If I, the buyer, was late on a payment installment by even a few weeks, the contract hit me with an exorbitant interest rate.
Usually around 18 to 24%, frequently compounded quarterly.
24%.
And if you disputed it, they retained the power to unilaterally cancel your allotment and forfeit your entire earnest money deposit, which, by the way, could be up to 20% of the total cost.
That is brutal. But if the builder was late on construction, say they delayed possession by 3 or 4 years, which we know was incredibly common, their penalty was almost comical.
It was completely nominal. A typical clause would offer the buyer compensation of perhaps 5 rupees per square foot per month of delay.
5 rupees per square foot.
Yeah.
If you calculate that out against the total cost of the house, it amounts to an interest penalty of maybe 1 or 2% per year. So if I'm late, I pay 24% compounding interest and might lose my house. If the builder's late by half a decade, they basically pay me pocket change.
It was the ultimate demonstration of asymmetrical risk. The buyer bore all the financial risk of delays, cost overruns, and economic downturns, while the builder just enjoyed a completely insulated position.
So the reason we are diving so deeply into these historical traps is because recognizing them is the very first step in reading your own contract today.
Absolutely.
You have to stop viewing the builder-buyer agreement as just a stack of clerical formalities you need to initial. You have to view it as a risk allocation document. Under the old system, the risk was entirely allocated to you. So how did we stop the bleeding? How did the law step in to shield buyers from these predatory practices?
The intervention came in the form of RERA. RERA completely changed the fundamental legal environment of the industry. It wasn't just a slight adjustment, you know. It imposed aggressive, non-negotiable duties of registration, public disclosure, financial discipline, and standardization on every real estate promoter.
Let's explore the mechanics of this shield, starting with Section 3 of RERA, the mandate for prior project registration. Because in the pre-RERA days, builders loved to do these soft launches.
Oh, they loved him.
They'll put up a billboard for a luxury high-rise, collect millions of dollars in booking amounts from desperate buyers, and they wouldn't even own the land yet.
Exactly.
They hadn't pulled a single permit. They were just using the buyer's money to go buy the land.
Which meant if the land deal fell through, the project died before it even started, and the buyer's money was just trapped.
So what does Section 3 do?
Section 3 completely outlaws that model. Today, a builder cannot advertise, market, book, sell, or offer for sale a single unit without first registering that specific project with the state RERA authority.
Okay.
And to get that registration, they have to prove they own the land, they have to submit all their municipal approvals, and they have to provide a definitive timeline for completion.
That's huge. And a massive part of that transparency mandate is the pro forma agreement disclosure. When the builder registers the project, they have to upload a blank copy of their template builder-buyer agreement to the public RERA portal.
Right.
Which, I mean, seems like a small administrative detail, but it prevents one of the oldest tricks in the book.
The classic bait and switch.
Yes.
Because previously, a buyer would tour a beautiful model apartment, review a glossy marketing brochure promising this really balanced transaction, and decide to buy. But months later, when it was time to sign the actual contract, the builder would slide a completely different, highly restrictive, draconian document across the desk.
And at that point, the buyer's earnest money is already locked in, so they feel forced to sign.
Exactly. Now, under RERA, the agreement you sign in the sales office must strictly match the pro forma template they publicly disclosed to the government. Any deviation is a statutory violation.
Okay, let's move to what I think is the most dramatic high-stakes protection RERA offers. The 10% rule under Section 13. How exactly does this work?
Section 13 establishes a strict financial threshold. It basically prohibits a builder from accepting more than 10% of the total cost of the apartment as an advance payment or application fee without first executing a written agreement for sale and legally registering that agreement with the sub-registrar.
I want to push back on this, or rather explore the reality of how this plays out on the ground.
Yeah.
Let's put ourselves in the shoes of a buyer in a highly competitive market. You go to a launch event. There is literally a line out the door for these new luxury units. People are practically throwing checkbooks at the sales team.
We see it all the time.
Right. So you get to the desk, and the builder looks you in the eye and says, look, I know the law says 10%, but this project is oversubscribed. If you want to secure your dream unit, I need 20% upfront right now, just as an expression of interest. We'll do the paperwork later. How does a buyer actually push back on that pressure without just losing the house to the next person in line?
That is the exact pressure cooker scenario that traps so many people. What's fascinating here is that the law actually anticipates that vulnerability, the fear of missing out. The 10% rule isn't just a speed limit placed on the builder, it is a vital boundary for the buyer's own financial safety.
Right.
If you yield to that high-pressure sales tactic and pay 20% or 30% without a registered agreement, you are voluntarily stepping completely outside the protective shield of RERA.
You are basically stripping off your own armor.
Yes, you are. You are transforming a highly regulated statutory transaction into a massive unprotected personal loan. If you hand over a fifth of the property's value without a registered document, you have no legally binding possession date, you have no defined carpet area, and most importantly, you have no statutory framework to demand a refund if the project stalls the next day.
Wow.
The builder has your money, and you have a receipt that essentially means nothing in real estate law.
It is a terrifying realization. Paying more than 10% without the formal, registered paperwork isn't securing the unit. It is actively destroying your own legal leverage.
Precisely. The power of Section 13 is that once that agreement is executed and registered, it triggers a cascade of standard compliances. It brings RERA Section 18 into play.
Ah, Section 18, this is the heavy artillery. If the builder fails to deliver possession on the promised date, or if they suspend the project, what happens?
Section 18 gives the buyer an absolute statutory right to a choice. You can either withdraw from the project entirely and demand a full refund of every penny you've paid, plus interest at a prescribed rate, or if you choose to stay in the project and wait for the house, the builder is legally mandated to pay you interest for every single month of delay until they finally hand over the keys.
Wow. It completely erases that old 5 rupee per square foot nonsense.
Completely.
And the accountability doesn't just vaporize the day you move in, right? Because for years, the industry standard was that the moment a builder handed over the keys, they just ghosted you.
Oh yeah, you'd never hear from them again.
If the roof started leaking 3 months later or the foundation cracked, it was your problem. But RERA introduced the statutory defect liability period.
This is such a crucial post-possession mechanism. Under the law, if any structural defect or any defect in workmanship, quality, or provision of services is brought to the promoter's notice within 5 years from the date of handing over possession, the promoter is legally bound to rectify it without any further charge.
5 years. I mean, that is a massive ongoing liability for the builder.
It forces them to actually care about the quality of the materials they use. If we connect this to the bigger picture, RERA effectively stripped developers of their previously unchecked dictatorial powers.
Right.
Once the agreement is signed, the builder cannot alter the sanction layout plans, they cannot change the nature of the fixtures, and they cannot remove promised amenities without statutory approval, and crucially, the explicit written consent of the buyers.
So the builder-buyer agreement has evolved from a tool of exploitation into a straitjacket on the builder's discretion.
Exactly. It completely flips the dynamic.
Okay, so RERA acts as the shield. It protects the mechanics of the transaction going forward. It prevents builders from drafting terrible contracts today. But my mind immediately goes to the thousands of people who bought property before RERA was fully implemented, or who somehow got pressured into signing a contract that still contained oppressive clauses.
Right, the legacy buyers.
Are those buyers just out of luck? Because we are taught from a very young age that a signature is permanent. You know, read the fine print. If you sign the document, you consented to it and you are bound by it. Does putting pen to paper mean you forfeit your rights?
This brings us to a really profound intersection of contract law and consumer rights. And the short answer is no. A signature on an oppressive document is no longer a death sentence for your rights.
Here's where it gets really interesting. This is the sword. the Consumer Protection Act of 2019, and the concept of unfair contracts.
It is incredibly interesting because it challenges a bedrock societal assumption about how contracts work.
Mhm.
Traditional contract law assumes that two parties sit down, negotiate as equals, and reach a mutual agreement.
Which we know isn't true in real estate.
Exactly. And the Consumer Protection Act, specifically Section 246, formally recognizes that in modern standard form contracts, there is often no real consent because there is no real negotiation.
Right. If my only option is to sign the pre-printed form or lose my life savings, I'm not negotiating. I'm being coerced.
You're being coerced. And the law now defines an unfair contract as one that requires a consumer to fulfill obligations that are wholly disproportionate, or terms that cause a significant change in the rights of the consumer.
Like what specifically?
This includes excessive security deposits, disproportionate penalties for breach, like that 24% interest we talked about, or clauses that allow a builder to terminate the contract without reasonable cause.
So if the text of the contract is fundamentally one-sided,
Then consumer courts have the power to strike down those specific clauses or even declare the entire contract void, even if you signed it.
now our sources make a very distinct point to differentiate an unfair contract from an unfair trade practice. We hear unfair trade practice all the time in the news. What's the practical difference here?
The distinction is really between the written text and the physical action. An unfair contract focuses entirely on the oppressive nature of the written terms themselves. The text on the page is the violation.
Okay.
An unfair trade practice, on the other hand, focuses on deceptive methods or physical actions used in selling or marketing.
Like false
Good
advertising.
Exactly, like circulating a brochure showing a massive swimming pool that the builder knows they don't have permits to build, or employing bait and switch tactics.
But in real estate, they often overlap, right? Like
Yeah.
you use one to get to the other.
Very frequently. A builder might use false advertising to get you into the sales office, which is an unfair trade practice, and then leverage that initial deception to make you sign an agreement with heavily one-sided compensation clauses, which is an unfair contract. The Consumer Protection Act allows you to attack both the deception and the resulting paperwork.
And this isn't just academic legal theory. The Supreme Court of India has come down incredibly hard on developers using this exact logic. Let's look at the jurisprudence, because the cases our sources highlight are massive landmarks. We have to talk about Pioneer Urban Land and Infrastructure Ltd. Versus Govindan Raghavan. Why is this case so important?
Pioneer is a true watershed moment. In this case, the builder tried to enforce a highly skewed contract that penalized the buyer heavily for delays while excusing the builder entirely. Exactly. The Supreme Court explicitly held that wholly one-sided clauses in an apartment buyer's agreement are not binding on the purchaser.
Wow.
The court essentially looked at the industry and said, "We see what is happening here. Contract law generally respects mutual consent, but consumer law has a duty to examine the harsh reality of bargaining power."
The phrase the court used, which the sources highlight, is that buyers were treated as captive financiers.
That phrase perfectly encapsulates the era. The court recognized that developers didn't view buyers as equal negotiating partners. They viewed them as a captive source of zero-interest funding.
Right, because the builder needed the buyer's money to actually construct the building.
Right. But once they had the money, they treated the buyers as an annoyance rather than an investor. Pioneer legally dismantled the illusion that standard form real estate contracts represent mutual consent.
Then there's another major Supreme Court decision. Irio Grace Realtech PVT Ltd. Versus Abhishek Khanna.
Yes. In Aereo Grace, the court dealt with the agonizing issue of delayed possession and a buyer's right to a refund. Builders would often argue that even if they were 5 years late, the contract didn't allow for a refund, only delayed possession.
Which is just crazy. We're keeping your money forever until we feel like finishing.
Basically. But the Supreme Court decisively reinforced that buyers cannot be indefinitely bound by oppressive contractual arrangements when the developer fundamentally fails to perform their core obligation.
Makes sense.
If a builder cannot deliver the apartment within a reasonable promised time frame, they cannot use their own drafted contract to hold the buyer hostage.
And just to round out the Supreme Court action, the sources mention an ongoing push in a case called Ashwini Kumar Upadhyay versus Union of India. This is about creating a national model builder-buyer agreement.
Which is really the logical conclusion to all of this litigation. The idea is if we know these standard form contracts are historically abusive, and we know courts will eventually strike them down, why force every single buyer to spend years in consumer courts fighting the same battles?
Right, it's just a waste of everyone's time and money.
Exactly. A statutory model agreement would establish a fair, balanced template from day one. It shifts the entire system from reactive litigation to proactive, structural fairness.
Okay, let's fast forward a bit. Say you've survived the under construction phase. The building is finished, RERA did its job, the Consumer Protection Act had your back, you get your keys, you move in. The builder packs up their sales office and leaves the property.
You think you're finally safe.
You think you're safe. But then a new threat emerges from inside the building itself. And this brings us to a highly complex governance issue. When your homeowners association or resident welfare association starts enforcing those old toxic builder clauses against you.
This is a deeply nuanced problem that catches so many new owners off guard. Eventually, a resident-elected HOA takes over the management of the building.
Right, your neighbors.
Yes. But instead of acting on behalf of the collective owners, the new HOA committee starts mechanically enforcing the old oppressive clauses from the original builder-buyer agreements against their own neighbors.
It's like a newly elected democratic government coming to power, finding a filing cabinet full of the oppressive, secret laws written by the dictator they just overthrew, and deciding to strictly enforce them just because they were written down on an official letterhead. It makes no sense.
That analogy perfectly illustrates the absurdity of the situation. It is a fundamental inversion of an HOA's purpose.
Right.
The entire legal and moral justification for an owners association is to administer the collective interests, rights, and lawful enjoyment of the owners. It is absolutely not created to act as a private enforcement arm to preserve the departed builder's contractual advantages.
So why do HOAs do this? Let's say an owner wants to sell their flat. The old builder agreement had a clause saying the builder gets a 5% transfer fee every time the property changes hands.
Typical clause.
Right, the builder is gone, but the HOA says, hey, the old contract says there's a transfer fee, so you have to pay us 5% to sell your own house. Is this just administrative laziness?
Or greed. It's usually a toxic mix of administrative inertia, a desire for association revenue, and a complete misunderstanding of a legal concept called privity of contract.
Privity. Okay, what does that mean?
Privity means that a contract is only legally binding on the specific parties who signed it. The HOA, as a corporate entity, is usually not a party to the private builder-buyer agreement executed years earlier between the builder and the original allottee.
So they legally have nothing to do with that piece of paper.
Exactly. Unless a specific lawful restriction has been formally incorporated into the registered bylaws of the association itself, the HOA has no automatic legal authority to enforce a private builder-drafted clause.
The sources are very strict about this. They explicitly call this behavior a fiduciary breach. If an HOA board uses member funds or weaponizes gate controls or levies penalties to enforce anti-owner clauses like arbitrary transfer charges or denying someone access to the swimming pool because of a rule the builder made up a decade ago, they are actively breaching their fiduciary duty to the owners.
Yes. This raises a critical question that every single association committee member needs to ask themselves before taking any action.
What's the question?
Does enforcing this rule protect the owner's collective rights and lawful enjoyment of the property? If the answer is no, and they are merely enforcing a restriction because the builder originally drafted it to exert control, the board is failing its fiduciary standard.
But what if the HOA holds a meeting and takes a vote? Say 60% of the residents vote to keep the oppressive transfer fee because they want the revenue for the association. Doesn't democracy win? Because the sources highlight something called the majority power limitation.
Right. A general body resolution or a majority vote cannot legalize an illegality. You cannot use the democratic mechanism of an association to validate an unfair contract term, override consumer protection law, or strip individual owners of their fundamental property rights.
So voting to enforce something illegal just makes you all complicit.
Exactly. A majority vote to enforce an illegal builder clause is just a recorded confession of a collective fiduciary breach.
So how should an HOA handle this? Let's role play this for a second. Put ourselves in the shoes of an HOA board member. You take over the office, you open the books, and you find all these toxic builder clauses governing things like parking allocations, transfer fees, and club access. The sources lay out a 10-step governance response. Instead of just listing them, let's walk through how a board should actually process this. What's the first thing they need to figure out?
The first step is pure identification. You have to isolate the exact clause being relied upon. Don't operate on rumor or how things have always been done.
Right, like actually find the text.
Find the text.
Yep.
Step 2 is determining who exactly is claiming the right to enforce it. Is the builder still lurking around trying to claim a fee, or is the association itself trying to collect it?
Which leads to step 3, examining the association's actual authority. Is the HOA legally a party to that specific agreement? Did the owner sign a contract with the HOA or just with the builder?
Exactly. And step 4 is where the legal analysis begins. You compare the clause with current RERA provisions, consumer law, and the municipal approvals. Does this clause even survive RERA?
Probably not.
Right. Step 5 requires the board to look at the impact. Does enforcing this clause harm an individual owner, or does it harm the collective class of owners?
And I imagine at this point the board realizes they are in way over their heads,
Usually.
which makes step 6 crucial.
Yeah.
Obtain independent legal advice.
Huh.
And the sources emphasize independent. You cannot use the law firm that the builder originally appointed to handle the conveyance deeds because they have a massive conflict of interest.
Yes, that is a huge pitfall. Once you have independent advice, step 7 is transparency. Place the issue and the legal opinion before the general body of members with full disclosure. Explain the risk.
And step 8 is the protective measure.
Yes. While all of this is being sorted out, suspend any coercive enforcement. Don't start deactivating residents' access cards or locking them out of the clubhouse while the lawyers are still figuring out if the rule is even legal.
Step 9 is the decisive action. If the independent legal advice concludes that the clause is unfair or unlawful, the association must formally, on the record, decline to enforce it.
And finally, step 10. If the builder threatens retaliation, or if the situation is legally muddy, the HOA should seek formal rectification or clarification from the RERA authority or a civil court.
That entire process represents a real structural shift in governance. The proper test for an HOA isn't, is this written in the old builder agreement? The only test that matters is this action lawful, fair, and beneficial to the collective owners?
The association must act as a protective shield for its members, not as a private collection agency for the departed builder.
Okay, we are entering the final phase of our deep dive. We are moving from historical context and legal theory to highly actionable advice. We call this the playbook. You understand your rights, you know the history. Now, you are sitting at the sales desk, pen in hand. How do you practically review a builder-buyer agreement? And if things go wrong, how do you fight back? Let's start with the red flags. What specific words or clauses should make a buyer immediately hit the brakes?
The first massive red flag is a broadly drafted force majeure clause. Force majeure translates to superior force.
Like acts of God.
Right. In contract law, it is supposed to excuse performance only for unforeseeable, unavoidable, catastrophic events, like a massive earthquake, a global pandemic, or a sudden change in national law that halts construction. But builders frequently try to stretch this definition.
Right, they try to use it as a get-out-of-jail-free card for their own bad management.
They will draft clauses that include routine business difficulties like a shortage of cement, a dispute with their own contractor, or delays in getting municipal approvals that they simply failed to apply for on time. If a contract allows a builder to claim force majeure for normal operational risks, you are absorbing all the risk of their incompetence.
Another absolute deal-breaker red flag. Any clause that allows the builder to offer possession without first obtaining an occupancy certificate or completion certificate, the OC or CC. Why is moving in early so dangerous?
Because offering possession without a valid OC or CC is illegal in almost all jurisdictions.
Really? Illegal?
Yes. An occupancy certificate is the municipal government's final declaration that the building has been constructed according to the approved plans, that the fire safety systems actually work, that the structural integrity is sound, and that it is safe for human habitation.
So taking possession without it
Exposes you to immediate municipal eviction. Furthermore, you cannot legally register the property title in your name without an OC, which means you don't truly own it and you can't sell it.
The third red flag our sources highlight involves undefined actual cost charges at the time of handover. Imagine this. The building is done, you've paid your installments for 3 years, you show up to get your keys, and the builder hands you a surprise invoice for thousands of dollars.
It happens all the time.
They claim it's for upgraded infrastructure, legal documentation fees, or water connection actuals, with zero itemized proof and no maximum cap.
It creates unlimited financial exposure right at the finish line. A legally compliant agreement must define, itemize, and cap all prospective charges at the time of booking. There should be no surprise invoices at possession.
And the final major red flag.
The dispute resolution mechanism, specifically mandatory arbitration clauses designed to block your access to statutory remedies.
This is a sneaky one. They bury a clause saying that if there's a dispute, you cannot go to court. You must go to a private arbitrator. And usually the builder gets to pick the arbitrator, and the hearings are held in a city hundreds of miles away from the project site.
They do that specifically to chill legitimate claims. They want to make the dispute process so logistically annoying, biased, and expensive that you simply give up.
Which is why doing the work before you sign is so vital. The sources provide a due diligence matrix. Let's walk through this as a conversation, deducing what a buyer needs to verify. Step 1 seems obvious: verify the project. But that means more than just Googling the name,
Oh,
right?
absolutely. It means going to the state RERA website, typing in the registration number, and verifying that the project status is active.
Okay.
It means checking the land title documents uploaded there to ensure there are no massive legal disputes over the land itself. And crucially, it means downloading the builder's pro forma agreement from the government portal and comparing it line by line with the physical contract they are asking you to sign.
Okay. Step 2 involves the money. We need to verify the financial clauses. I assume this means looking past the big, bold base price number.
You have to build a comprehensive cost sheet. You need to calculate the exact impact of GST, the stamp duty for registration, the advanced maintenance deposits, the club charges, and the parking fees. You need to understand your total outflow, not just the marketing price.
Step 3, verify possession and approvals. We already touched on this, but you need a definitive calendar date for possession. December 31st, 2026, not 36 months from when we feel like digging.
Yes.
And that date must explicitly be tied to the receipt of the occupancy certificate.
Step 4 is verifying title and conveyance. You need to ensure the agreement contains a clear, enforceable timeline for when the builder will execute the final conveyance deed, legally transferring the title of the apartment to you, and when they will transfer the title of the common areas to the owners association.
And finally, step 5, verify common areas and amenities. If the glossy brochure promises an Olympic-sized swimming pool, a massive gym, and a landscape park, you need to verify that those specific amenities are explicitly listed in the legally binding agreement.
Right, because if they aren't on the contract, they don't exist.
So if you execute that due diligence matrix, you place yourself in a vastly safer position. However, real estate is inherently unpredictable, and disputes still happen even with good contracts. When they do, a buyer needs a clear forum strategy. Where do you go to fight?
Right, because there's a whole menu of legal options now, and picking the wrong one can waste years. Let's break the strategy down.
Okay, if I have a problem with the project's registration, or a massive delay in possession, or I want to demand a full refund with interest based on statutory violations, where is my best battlefield?
For issues strictly related to the mechanics of the project delays, registration failures, refund demands, and enforcing the statutory obligations of the promoter RERA is your primary and most effective forum. It was custom built by the legislature to handle exactly these disputes quickly.
Okay, but what if the situation is different? What if the builder actually delivered the house on time, but the service is terrible, the construction quality is completely deficient, or they engaged in massive deceptive marketing?
Like, what if the ordeal caused severe mental agony and you want compensation for unfair trade practices?
In that scenario, your best forum is the Consumer Commission, and the jurisprudence here is very clear. It's important to note the Supreme Court case of Imperial Structures versus Anil Patni.
That is,
The court affirmed that the existence of RERA does not bar a consumer from approaching the Consumer Commission. The remedies provided by the Consumer Protection Act are in addition to, not in derogation of, RERA. They can coexist.
And what about the traditional civil court? When do you hire a civil lawyer and file a regular lawsuit?
Civil courts are best reserved for highly complex title disputes involving multiple parties, seeking injunctions to stop a builder from illegally selling the same flat twice, or issues of specific performance that fall outside the streamlined regulatory scope of RERA or the Consumer Protection Act.
So what does this all mean for you? You have options: RERA, Consumer Commission, civil court. But I want to push back here because I hear this exact sentiment from frustrated buyers all the time.
Sure, go ahead.
Let's say a builder's driving me crazy. They took my money, they stalled the project, they won't answer my calls, and they're clearly lying to me. Instead of spending years in a civil or consumer court, can't I just go to the local police station, file a criminal complaint, claim fraud, and scare the living daylights out of them until they give me my apartment or my money back?
If we connect this to the bigger picture of legal strategy, the sources strictly, unequivocally warn against the casual use of criminal remedies as a pressure tactic. You cannot simply file an FIR, a first information report, with the police to force a settlement in a contract dispute.
But why not? I mean, from a common sense perspective, if they took $500,000 of my money and didn't build the house they promised, isn't that just stealing? Isn't that a crime?
It feels like a crime to the victim, but in the eyes of the law, a mere delay in construction or a failure to uphold a promise is a civil breach of contract. To successfully pursue a criminal complaint, you have to prove criminal intent mens rea from the very inception of the transaction.
So you have to prove they planned to steal from day one.
Yes, you have to prove actual deliberate fraud, blatant forgery of documents, criminal breach of trust, or dishonest misappropriation of funds. If the builder genuinely intended to build the project, but they ran out of money due to market conditions, or they managed the construction poorly, that is a civil failure. It is not a criminal act.
The police will just see right through it.
The police and criminal courts will quickly recognize a civil dispute dressed up as a criminal complaint and throw it out.
And speaking of having cases thrown out, the sources also heavily caution against something called forum shopping.
Yes, this involves the legal doctrine of the election of remedies. While you have multiple forums available to you, you can choose RERA or you can choose the Consumer Commission. You absolutely cannot pursue duplicate proceedings for the exact same relief at the same time.
Right.
You cannot file a case in RERA asking for a refund and simultaneously file a case in the Consumer Commission asking for the exact same refund, hoping one court decides faster than the other.
It's like double dipping.
Exactly. It creates inconsistent claims, wastes judicial time, and will almost certainly get your cases thrown out entirely on maintainability objections. You have to evaluate your specific injury, choose your battleground strategically, and stick to it.
Okay, we have covered an immense amount of ground in this deep dive. We started in the murky, terrifying dark ages of pre-RA real estate, exploring an era where you, as a vulnerable buyer, were forced to sign standard form contracts that stripped away your rights. You are paying for the invisible heir of the super built-up area and facing ruinous 24% compounding interest penalties while the builder faced virtually zero accountability.
And we trace the incredible evolution of the law. We examined the shield of RERA, which mandated prior registration, established the protective 10% payment threshold, and enforced strict accountability for possession dates and defect liability.
And we explored the sword of the Consumer Protection Act, which empowered the Supreme Court to look past the ink on the page and strike down fundamentally unfair one-sided contracts that treated buyers merely as captive financiers.
We tackled the Trojan horse of HOAs breaching their fiduciary duty by acting as private enforcers for departed builders.
And finally, we laid out a concrete, actionable playbook for reviewing your contract line by line, spotting the red flags of force majeure and missing occupancy certificates, and choosing your legal forum wisely without falling into the trap of forum shopping or frivolous criminal complaints.
Ultimately, the overarching lesson here is that a builder-buyer agreement is a profound risk allocation document. But transparency and fairness are no longer optional favors granted by benevolent developers. They are rigorous statutory requirements enforced by law.
You have to treat yourself as a rights-bearing consumer. Verify the carpet areas. Demand definitive calendar possession dates linked to municipal approvals, and absolutely refuse to accept the old narrative that a printed clause in a standard form contract is untouchable law. Before we wrap up today, I want to leave you with a final thought to mull over. Building on the Supreme Court's description of the homebuyer as a captive financier, think about how truly wild the real estate industry is compared to literally anything else you buy in a modern economy.
It's unique, for sure.
You are essentially financing the creation of a massive, multi-million-dollar product years before it even exists. Imagine walking into a car dealership, paying 90% of the cost of a car that hasn't even been designed yet, and signing a contract saying the dealer can change the engine size without telling you, delay delivery by 3 years, and charge you extra if the metal costs go up.
It is an absurd proposition when applied to any other industry.
Why did society ever accept this as normal for our most expensive purchases? As statutory model agreements become the standard, and as courts force developers to bear their own business risks, it raises a fascinating question. Will the future of real estate look less like a terrifying speculative gamble and more like buying a finished, polished product right off a shelf? It's something to chew on.
It is a massive paradigm shift, and we are watching it reshape the economy in real time.
It really is. Remember, the landscape of real estate doesn't have to be a blurry pencil sketch anymore. You have the tools, the laws, and the knowledge to demand a clear picture.
Thank you so much for joining us on this deep dive. Stay curious, stay informed, and we will catch you on the next one.